Okay, tēnā koutou katoa. Welcome back, everybody, and welcome to Waitangi Estate Limited. Welcome here. So you've got quite a delegation, which is good to see you all in person. We'll hand it over to you to present your submissions.
Mr. Chair, before you do, can I please just introduce the archaeologist
Yes,
for the
of course.
council? So joining us this afternoon is
Come down at the end there.
Dr. Andy Brown. So he joins us, and he's one of the experts from the council. Would you like to hear from him at all, or would you just?
Unless Mr. Brown needs to add something or just respond. I mean, we're running a reasonably iterative hearing process at the moment. We're inviting council to respond to evidence here. So you'll have a chance, Mr. Brown, if you would like to put some input. Yeah. Thank you and welcome. Okay, so back now to
So thank you, Commissioner. Yeah, kia ora, tēnā koe, kia ora tātou katoa. Dave Randall is my name, and it's a real privilege to be here. Thank you very much to the Commissioners for hearing his submission. Huge mihi, of course, to others in the room, the hardworking reporting officers, representatives of Heritage New Zealand for He Taonga, Kaikohe, of course, tēnā koe will be very well supported through this process. It's a very exciting day for Waitangi because this is a big deal. This submission will be a big deal for it, the future of the estate, the way it runs. That special place will be benefit of us all. The plan, just in terms of speaking to the submission, of course, you've seen some of us before talking to other aspects of the submission for Waitangi Limited, particularly the secondary relief, the sort of fallback relief.
Yes.
Through the hearing streams. Today, of course, it's all about the main event from Waitangi's perspective, which is proposed, special purpose zoning for the estate as a whole, which is the primary relief. The real key for unlocking the positive outcomes for the estate, and the main, reason for the submission. So yeah, it's an exciting day for this team.
And we've indicated, since hearing Paul when we first saw you, that we are encouraging of the primary relief to see that you get there. And I think you've made really good progress to date. And we're thanking all of the submitters for opting into this process. It takes two to tango, as they say, and you've embraced it really, really well. And this has come through from the office reporting as well. So we're really, really pleased to see that part of the process working for both parties. It's certainly making our job a lot easier.
Thank you. It's great to hear that, and I mean, thanks to you also for it needed. A good process is always needed to bring people together and get people engaging on the right issues and talking before we get to this spot. You wouldn't want to be starting afresh on this day.
Yes.
So thank you for doing that.
It was your evidence and others out here in general really helped, and we think how we handled the rezoning request, particularly when it came to zones that don't exist yet. And, so that really got us thinking about the process by which we sort of flipped the script and the applicant and the submitter initiate that process. And so thank you again for raising those issues back in May this year.
And likewise to the officers of the same. What we're happy to head in different directions if that's best for the commissioners. But what we were thinking is that we've started off with Rochelle Jacobs sort of presenting a brief overview of it. We appreciate that you've had a lot of material.
We have read the evidence.
Yes.
We can do with some reminding.
Yeah, me too. So that's how we would suggest an overview, and I think Rochelle's got some slides she can speak to just to talk about the zoning proposal scheme as a whole. Then this is Libby Cowper, my colleague from Finlay. Then Libby, with some support from me, will present legal submissions to you, just a little bit of the legislative context. And there are two legal issues proper about the National Planning Standards tests for special purpose zone and highly productive land at MPS, which you may have done to death already, I'm not sure, but I'll talk to you a bit about that. And then we have 3 witnesses who have provided rebuttal evidence on the live issues. There are only a small number, as you will have seen, of technical planning issues to work through. And the order we were proposing to go through them is Ben Dalton, who's the chief executive seen before, Simon Cocker is the landscape architect down the table, and then Rochelle last. Ngahuia Harawira is here as well. She gave primary evidence and prepared a cultural values assessment. Not matters of just any dispute, I think, between the officers, but she's here in case the commissioners have any questions or so those are the witnesses. Conscious there's a site visit scheduled for later in the week.
Wednesday, we're looking to do Wednesday.
And so I don't know if it's worth spending any time now, or perhaps we can do it offline with AK or others. If the commission has had any particular matters that they want to sort of scheduled in, or if it's worth discussing any details of that today, we can do that too. Or
well, we're reasonably familiar with the treaty grounds, having held one hearing there already and another one to come. So we know the treaty grounds quite well, but the rest of the property, which is quite large, we're not that familiar with. We don't need to see every bit of it, so we're sort of wanting to be guided by you in some ways as to what things you think we might need to see. We're asking council officers also to give us guidance what they think we might need to see. So we're sort of making it an open process at this stage. And it seems to me that once we hear the evidence, I think some of those things are making themselves clearer.
I should note that Ralph, where are you, Ralph? Ralph Johnson will be one of your guides on the day. So
we'd be happy to be guided, but we probably prefer it being guided around.
Okay, well, thanks. Good to have that exchange. So otherwise, we'll get into it if that's right with you.
Yes, absolutely.
With Rochelle's overview. There's an AK, this is where there's the Thank you.
Kia ora, my name is Rochelle Jacobs. I have prepared primary and rebuttal evidence on behalf of Waitangi Limited in relation to its submission on the proposed Whānau District Plan as it relates to hearing 15B. Waitangi Limited's submission relates solely to the Waitangi National Trust Estate, which contains the historic Waitangi Treaty Grounds known as Te Whitu Whenua. It is responsible for managing the day-to-day operations at the estate. My primary evidence for this hearing sets out my involvement in advising Waitangi Limited on Whānau District Council's plan review, including my involvement in preparing the Waitangi Estate Special Purpose Zones, WES provisions, and the accompanying Section 32AA report. Today I'll provide a brief overview of the estate and the proposed WES via a PowerPoint presentation. I'll then address several unresolved technical matters relating to the WES provisions as raised in the Council's Section 42A report. I'll discuss some minor amendments I have identified in my review of the Council's recommended version of the WES provision, which are amended to its Section 42A report. Finally, I'll also briefly respond to matters raised by Dr. Andrew Brown, the Council's consultant archaeologist, in his review of the Waitangi Estate is a large 506 hectare landholding located north of the township of Kaikohe at Waitangi. The estate contains the nationally significant historic Waitangi Treaty Grounds, which is the location of the signing of the Treaty of Waitangi on 6th of February 1840. The Waitangi Estate is the venue for annual National Waitangi Day Hui and public commemorations. The estate comprises 7 titles and 2 long-term leaseholds. The leasehold properties are held by Cosmentum Corporation Limited and Context Securities Limited, otherwise known as Millennium and Copthorne Hotels, and Waitangi Golf Club Incorporated. The majority of the built development on the estate is located on Lot 1 DP 326610, which is 411 hectares. This includes the historic treaty grounds and associated buildings and objects. The site is also home to 2 sports grounds, boat ramps, jetties, public toilets, and a yacht club. As has been hashed out, hearing 4, 6, 7, 9, and through evidence, the general zoning of the Waitangi Estate is not suitable in protecting both the cultural heritage on site, nor does it enable the continued promotion of tourism across the estate. Both the protection and promotion of heritage through tourism go hand in hand with each other. Essentially, in order to effectively maintain the historic heritage on the treaty grounds and ensure the visitor experience meets health and safety standards and keeps up with technological improvements, considered development on the remainder of the state needs to be enabled. An assessment of various options has been considered through the Section 32AA analysis provided as part of the suite of evidence supplied. The Section 42A highlighted that the development area, specific control layer, heritage order and designation options under the National Planning Standards were not included, but through consultation and in its Section 42A report has addressed this, confirming that these options are not viable for the estate. As part of the Section 32AA, it was determined that a special purpose zone was the most viable option. The National Planning Standards have very strict criteria which must be met in order to establish a new special purpose zone. The Section 32AA has also covered off these tests, determining that the application of a special purpose zone is a viable option. The Section 42A report highlighted one matter being the National Policy Statement for Highly Productive Land, where they did not agree with my argument. However, the Section 42A report writer has reached the same conclusion that the NPS HPL does not prevent the rezoning of the estate for the Waitangi Special Purpose. Waitangi Limited has proposed a new special purpose zone for the estate, and specific special purpose and district-wide provisions have been developed, which is attached at Appendix A to the Section 32AA report. This includes overarching objectives and policies which direct the type of development being sought from the estate. The special purpose zoning includes subzones similar to the Kaikohe Cliff Special Purpose Zone. The purpose of these is to reflect and provide for existing activities within the estate boundary and enable appropriate future activities within the subzone locations and the wider estate generally. District-wide environment overlays and general provisions would continue to apply to the Waitangi State Special Purpose Zone. A number of these have been amended as part of this overall proposal, either by adding in a reference to the new special purpose zone or making amendments which specifically reflect the activity on the estate. These provisions have been assessed by the Council through the reverse timetabling process, which involves sharing of documents ahead of the hearing and various meetings to discuss detail. Through this process, the majority of provisions have been recommended for approval. The Council recommended provisions are included at Appendix 3 to the Section 42A. The proposed objectives and policy have had input and comment from Section 42A report writers Lynette Murray and Melissa Pearson as part of the reverse timetabling process. These objectives and policies have also been discussed at length with Cape Knight, the planner engaged by Millennium Copthorne Hotels Limited and the Waitangi Yacht Club. There has been agreement to adopt the changes. The objectives provide for the protection, management and development of the estate lands for historic interest, recreation, enjoyment and benefit of the people of New Zealand. Ensure that nationally significant historic heritage comprising New Zealand's only national landmark is protected from inappropriate subdivision, use and development. Multicultural relationships within the site and its coastal surrounds are recognised and provided for. Natural characteristics and landscape features are protected from inappropriate land use and subdivision activities, and activities which are supporting the historic interest of the site provided. For the policies, while the themes are consistent with what was sought at time of submitting evidence, through consultation with Council, MCK and the Yacht Club, some changes to the layout of the policies have been offered, especially in respect of the subzones and how these have been shown. The changes now result in a clearer direction to the planned user. A new policy has been included, WESP 2, regarding commercial activities. This flows through to changes to commercial activities. There has been a lot of consultation with Council, Heritage New Zealand, Hawthorne, iwi, the Waitangi Yacht Club and the Waitangi Golf Club in the creation of the objective policies and rules. Post submission of our full proposal, additional meetings with Council have been undertaken as well as informal discussions with other stakeholders. This has resulted in achieving consensus for the majority of matters which are listed. As detailed within Section 6 of the Section 42A report, the report writer states, I agree in principle with the Waitangi submitters that a special purpose zone combined with targeted amendments to district-wide chapters is the most appropriate planning response to both protect the historic, natural and cultural values of the Waitangi estate, but also direct and enable an appropriate level of development, particularly in areas outside of the Tupatua subzone where there are more opportunities for compatible commercial, recreation and tourism related activities. Those matters for which consensus could not be achieved at time of writing the section 42A as follows. And note that as a result of rebuttal evidence that those matters relating to WES R6 and CES 4 have now been satisfied. This leaves NFL R1, Sign R15 PER1, Sign S3 and TARX, as well as some minor amendments. I'm going to stop at this point and have been discussed, and I'll come back to the rest of the planning matters. Sorry, legals up first and then come back and discuss planning issues at the end.
Thank you. Libby will start us off with the legal submissions, which were filed late last week. Put some hard around together with a single sheet, which is an extract from the community feeds guidance. Yes.
Commissioners, thank you for the opportunity to speak today. As Dave mentioned, my name is Libby Cowper, and I'm going to run you through the background Limited's submission before addressing the first of two legal considerations that will be relevant to your decision of the proposed Waitangi Estate Special Purpose. Its primary relief. Firstly, if I could just direct your attention to paragraphs 2.1 to 2.4 on pages 3 and 4. I propose just to speak to the sections rather than to go through it paragraph by paragraph. This section in particular outlines the estate's unique legislative and governance framework that guides its administration, management and control. The framework was discussed briefly at hearing 4 and is explained in the evidence of Mr. Walton and Ms. Rochelle Jacobs. I propose to go into a little more detail on this framework today, as we indicated we did in our hearing. The Waitangi National Trust Board Act 1932 is the primary legislation that enables the Trust Board and Waitangi Limited to manage the estate. It is a key consideration when assessing the rezoning of the estate to the proposed special purpose zone. Put simply, the Act did three things that provide important context for the proposal. Firstly, it fixed the estate in the Waitangi National Trust Board was established by the Act, and it records the gift of the estate by Lord and Lady Bledisloe to the people of New Zealand in perpetuity as a place of historic interest, recreation, enjoyment and benefit. And this is expressly reflected in the preamble to the Act and in clause 13 of the trust deed at Schedule 1, which sets out the terms or purpose for which the land is held in trust. Thirdly, it sets out the Trust Board's powers and responsibilities to manage the estate in accordance with the trust deed. There's a lot of powers in there, including constructing buildings such as monuments, museums, art galleries, libraries and hostels, landscaping and planting, creating recreational grounds, farming, building and maintaining infrastructure, and entering into contracts for capital works. All must be done in furtherance of the purpose and objects of the trust. In addition, Section 7 provides for the making of bylaws, including for the management, use and preservation of the land and geography, and relevant temporary events, which will be discussed a little later on, regulate the admission of people to the estate. The statutory model is unique, and in accordance with the treaty grounds and surrounding estate are administered by the Trust Board and its operating company Waitangi Limited as a taonga as a place of belonging, a tūranga waiwai for all New Zealanders. As Mr. Dalton explains in his primary evidence, the day-to-day operational and commercial management of the estate has been delegated to Waitangi Limited. established in 2006. Under its board and chief executive, Mr. Dalton, Waitangi Limited is responsible for running the estate, delivering visitor services, maintaining assets, and carrying out capital projects in accordance with the Act. The estate's legislative history and purpose distinguish it from other properties that sit inside a conventional planning zone. Its governance, its public gift in perpetuity, and the statutory powers it affords to the trust means that the site can lawfully accommodate a range of public-facing activities and infrastructure for its historic, cultural, and recreational purposes. It is unique in that the RMA is only one part of the legislative matrix that applies to the site. Entirely self-funded, revenue-generating activities and developments must also be provided for by the special purpose zone. Special purpose zone directs and enables appropriate development, particularly outside the Te Whenua or treaty ground subzone, where there are more opportunities for compatible commercial, recreation, and tourism-related activities. That approach, which includes the enablement of defined commercial activities in appropriate subzones, it's WES Rule 4, is accepted by council officers in the 42A report. Overall, the special purpose zone has been designed to recognise the estate's special status and to provide planning tools aligned with the Trust Board Act and the trustee to guide its future management, use, and development. I'll now just take you down to paragraph 2.6 under heading unworkability as a proposed plan provision. Negative sounding thing. I propose to only briefly touch on this point, as Ms. Jacobs has spoken to this in her introduction and in detail in evidence for hearings 4 and 15B. And of course, it's canvassed in detail as well in section 32A and 4. The issues were discussed hearing 4 and dispute. I will just say though, in short, the notified provisions are misaligned with the Act in the estate's national historic significance. The proposed mix of zones and overlays, particularly the prevailing rural production, would unduly restrict routine maintenance, physical services and activities needed to manage the estate. The bespoke training framework is therefore required to enable the sustainable management of the estate in accordance with the Trust Act. Down to paragraph 2.8 and 2.9, which outline Waitangi Limited's involvement in the final district plans to be approved today. As you will be aware, Waitangi Limited has actively participated in early hearings and has filed evidence for hearing 1, strategic direction, Te Whenua and Plan, hearing 4, coastal and natural environment, where we appeared, hearing 6 and 7, general district-wide matters, and hearing 9, rules and that evidence set out its secondary relief should primary relief for special purpose zone not be accepted. Proposed use of a special purpose zone was addressed in legal submissions and evidence filed for hearing. For convenience, those hearing 4 legal submissions are appended to these submissions on page 20. Of course, the rezoning of the estate is the focus of this hearing. Michelle has touched on this as well, but the development of the proposed special purpose zone, I addressed briefly at paragraphs 211 to 214 of the legal submissions. Waitangi Limited has worked proactively and constructively with council, council and stakeholders to develop the special purpose zone framework over the past 18 plus months. In accordance with the panel's reverse timetable process, Waitangi Limited prepared detailed analysis on the proposed rezoning, listing in section 32A, and drafted the original special purpose zone provisions that were included in the appendix. The special purpose zone proposal and those provisions were developed collaboratively with council officers, local hapu, the Te Marae, Heritage New Zealand Pahiuri Taonga, and other stakeholders, all of which have subsequently expressed their support for the proposal. Notably, Heritage New Zealand Review Parliament has since formally amended its position to support the proposed special purpose sign. As part of this process, Waitangi Limited also commissioned a cultural values assessment by Ms. Natalia Hararia. It was presented today, which is being museum and available to answer. Hararia's report records support from the Haukāinga, which is the term used to describe local and neighbouring Hapu and iwi, including Ngāti Rahiri, Ngāti Kawa, Masaraga Tapu, and the wider Te Whare Tapu o Ngā. In filing evidence, Waitangi Limited, Heritage New Zealand Council and other submitters have engaged at length and agreed a number of fine provisions which are appended to the Section 42A report. The Section 42A report records the high degree of alignment that now exists between. As Rochelle has mentioned, you will have seen that the Section 42A report records now only a handful of unresolved technical matters. These will be addressed in later presentations by Mr. Dalton, Ms. Jacobs, and Mr. It includes the background section of our submissions. I'm happy to take any questions that you may have before I move on to the first of two legal considerations, which is a test for a special purpose sign for the national tax.
Thank you. I don't think we have any further questions there. Are we at 3.7 now? All right.
So we've just made it to 3.1.
3.1. It's good to hear.
I think it's all pretty factual stuff you're providing, so
I was just going to say, is clause 8.3 of the National Planning Statement, standard, sorry, is that in contention at all between council officers? I mean, I think with some other submitters, you all agree with the endpoint, but maybe how you got there. Is this one of these ones?
And that's correct. I think that
I know there's an issue with the NPS-HPL. That's a different issue. In terms of its criteria of the NPS purpose.
we all agree with the end point. It's how we got there. But that's a matter for the panel.
That's fine. If how we got there is still in contention, you still want to make, or why we agreed with the route we followed.
So with the special purpose zone tests, Ms. Morgan was happy with criteria, the analysis that was provided for criteria A and B. Of course, there's also C, and she felt that some of the layers were missing. Some analysis was missing essentially, and helpfully provided that analysis in her section 42 report. And so basically we just want to sort of confirm that we agree with that. Yeah.
I don't think we don't need to dwell on that. If you agree with her analysis, we're probably interested in the fact that you've agreed with where you got to and how you got there. Yeah.
Yeah. That's all from me.
Okay. Sorry, I didn't need to cut you off short, but I thought what we're trying to do as a panel is really focus on those matters that are in contention.
Thank you, sir. I'll pick up from there and feel free to cut me short too, because highly predictive land isn't really in contention either. But this, I think this is what Morgan's talking about. How?
Yeah.
How exactly. So I can address you briefly on that.
Yeah, I mean, we're all aware that it's quite a narrow pathway.
Yes.
When it comes to plan changes, it's very confused as to how narrow that should be.
Yes.
Yeah, I think there was agreement with that you get there. It was really just about how you got there. And obviously we had there's a lot of further analysis that's been offered, particularly by Ms. Pearson, in conjunction with Mr. Wyeth. Do we agree with that, or do you want to offer some nuance in terms of that, that approach?
It's a little bit of nuance, if that's okay. So
Well, then I'll leave it anyway.
I mean, I think as between the planners, there's a degree of comfort with the route chosen. I can explain it to you and summarise. For my part, there are two other ways to get there. So it's sort of, and I propose to sort of explain those briefly to you in case the commissioners had any discomfort with where the plan is.
I suppose where I really want to put to you is there anything that you want us to make a finding on? Or we just explain where we all agree?
It's, yeah, so, I mean, if we're working with a premise that the commissioners are going to recommend that special purpose zoning, is an appropriate outcome, and the EPS HPL doesn't present a barrier to rezoning the estate in a way. That's the finding we're after.
But also, I mean, I suppose what I'm saying is that
Yeah.
you want us to make a finding on how you navigated your way through the NPSHPL, or are the council and Kaikohe both agreed now on how you get it? Or do you think there is a little, we are conscious of getting it right as well. We don't want to skip over some of that detail and find that, it left some unanswered questions.
So you're asking exactly the right questions, and sorry for hesitating and responding to you. As legal counsel, I'd quite like to give you what I think is the best,
Okay.
the most legally correct avenue to get to that.
Well, then we're definitely interested in that.
Thank you. So, yeah, there's quite a long section of these legal submissions with quite a lot of detail in there, which I'll largely take as read, but I will try and explain as briefly as we can. So I'll skip over this introduction and background, the overview section, but highlighting one point, which is at 4.7, the Otago quote here. I mean, you will understand that interpreting a planning instrument like the NPS HPL isn't simply a reading of the words out of context. One needs to interpret the words of planning instruments in context and in light of their purpose. The purpose here, or the objective I've set out at 4.8, highly productive land is protected for use in land-based primary production, both now and future generations. It's a general interpretive principle. Hold that thought. As you say, Mr. Chair, there's a narrow pathway through for rezonings, and the Environment Court, they've been applying their EPS quite stringently.
Yes.
So I had that quote at 4.10 from Judge Smith's division of the court in that garden trust case. So that's a case where His Honour actually, the court did allow an urban rezoning of highly productive land. And so, the judge sort of says that the exceptions are to be construed pretty narrowly. But nevertheless, he goes on to say, the tests aren't intended to exclude all development on elite prime soils, and where a proper exception is established, an allowance should be made on a reasonable basis. That's fair finding from design. I won't take you through the next page about the policies and the implementation aspects of the HPL. But picking up at 4.15, it's on page 14. I mean, you will have gathered this from the papers. Technically speaking, the NPS is relevant to the estate. That's what I'm talking about. But it might not always be so, and it's an interesting part of the context here. The NPS is premised, and really, when it becomes sort of in a more workable state, it's premised on the regional council undertaking a mapping exercise to substitute in some more finer grained information about where these soils are, substituting it in for what's currently there, which is the results of a desktop exercise undertaken by Manaki Whenua and Care, a nationwide desktop, very coarse level, high level analysis, which is kind of what we're stuck with at the moment. So the region in this region, as you may know, that council's mapping process, the detailed mapping process, hasn't yet started. The deadline for that to start is actually next month. So it's imminent.
And we've had evidence from the regional council,
Right,
that they're not interested in doing any mapping. The government sets some very clear direction as to what is not highly productive land. So we're going around the circle.
Yeah.
And all the time, we're stuck in this interim situation. We've got these very old updated maps that look like they've been drawn in green and crayon. Which constitute highly productive land if they are.
Yes, yes.
And it's, you know, and all those difficulties that go with it. And so those pathways, albeit how narrow they are, become like really important because they're going to be around for a wee while.
Yes.
And well, unless the government
Well, that's
restructures a little bit more of the instrument in the signal, just in terms of what classes are included.
yes, yes. So you're across that as well, and that's the other. It's a very strange point in time today. You know, if they're talking about the surgery, because as you heard, government intends, have said to remove LUC, you know, class 3 land.
And just in spirit of disclosure, Garden Trust, I mean, I was on the hearing panel that won't take decisions, so, and we struggled with that issue. Some length. So that's why I was sort of wanting to skip to the chase, because sort of
I get it. So, I mean, you will have gathered, for now though, based on the LRI mapping, it's relevant, of course, because the operative zoning of the estate is part rural production and part coastal, which is an equivalent zone, and it corresponds in a number of places with LUC 2 and 3 there. And the courts have clearly said, until that detailed mapping exercise is undertaken, we stuck with that until mapping. You might have noticed in the 32A report, appended to it, there's a specific soils report, where the detailed investigation has been done, and lo and behold, there is very little, only class 3 land on the estate, so quite conceivably, imminently, it won't be relevant at all. But Waitangi understands that it can't ask you to rely on that soils report. It's not bad.
Yeah, that's right. I mean, the problem I think we have is reconciling that factual analysis
Yes,
with the pathway 3.6.
yes, yes.
I mean, so that's really where we'd like to see some guidance from you.
Thank you. Yeah, let me take you there. Thank you. And I think I get into that at the top of page 17. So you know, your policy 5, it's an avoid urban rezoning of basically rural productive land. Unless, as you say, those exceptions in 3.6 apply. And you understandably, the planning officers have engaged with that exception. And it's understandable because you look at you try and work out what urban rezoning is. You look in the MPS, it takes you to the definition of urban. As you know, it's got that list, which I've set out there at 4.26b. And down at E, it says any special purpose zone other than a Māori purpose zone. And of course, that definition links to the National Planning Standard 8, the zoning standard. And on the face of those words, any special purpose zone other than a Māori purpose zone might mean this special purpose. But actually the better interpretation is that with that linkage to the National Planning Standards, what those words mean is urban means any of the listed special purpose zones in zone standard 8, other than a Māori purpose zone. And I'll explain why, but I understand that requires a contextual reading of those words.
So in other words, you're saying, section 8 of the MPS lists literally a number of zones, corrections zones. And so what you're saying is that you can make a distinction between the unlisted special purpose zones that are 8.3.
That's right. That's right. Yeah, the draft is it's clumsy. The drafters of the MPS HPL have looked at that list of special purpose zones, and lo and behold, they're pretty much all urban. You know, stadiums, hospitals, and so on. There's Māori purpose zone, which is of a different character, and the drafters of the MPS HPL hadn't really engaged with the catch-all. There can be other types of special purpose. And that's where that single page that I've handed up accompanying submissions comes in handy. And of course, this is MFE guidance document. And as you'll know, famously, you know, the MFE guidance documents you take them with a grain of salt, because they're not conclusive, they're not authoritative. But it certainly does support that contextual interpretation I'm inviting you all to take, and it's the highlighted piece there on that page. So this is a discussion about rezoning HPL to an urban zone. The paragraph above the highlighting begins, the zones that are considered to be urban are defined, 4.3, includes nearly all the zones defined in Schedule 8. But note that, firstly, rezoning of HPL to a multi-purpose zone isn't covered deliberately. Then, crucially, the next one, the reference to special purpose zone within the definition of urban is intended to capture the standard special purpose zones listed in the zone framework standard, not intended to capture bespoke special purpose zones that may be more rural in nature when considering the nearest zone. And that's really what we're talking about here. This is this is not an urban rezoning properly construed. This is not a rezoning about the urbanization, making more urban the Waitangi estate. It's a planning tool that rationalizes zones in a way that actually sort of reflects current uses, more or less. But yeah, it's not opposite. It's kind of anomalous to be thinking about the HBL in the context of the estate, and I think everyone's grappling with that. Everyone's going, oh, does it come through 3.6, or why are we even thinking about protecting highly productive land? We're talking about the treaty grounds, Is it really a proper planning purpose that this district council should be thinking about preserving the soils beneath the treaty grounds that might technically be productive for the productivity needs of now and into the future? It just doesn't really fit. And so yeah, coming back, that's why I say the best way to get actually through the MPS HPL is to think that this is not actually an urban rezoning at all.
So it's urban in terms of a structural sense, but not urban in terms of a real sense.
I think it's urban only in a technical sort of apply the words. Urban says any special purpose zone, and then if you
structural.
Yes.
That it's been set up in such a way that urban means this thing,
Yes.
which in the real world doesn't apply.
That's right. That's right. So on the face of the words, urban includes any special purpose zone. But when you think about the purpose of the MPS HBL, and you interpret those words in context, the better interpretation is that those drafters meant what MFB says they meant, actually, which is that they meant to capture as urban all of the types of special purpose zone listed in that stands apart from multi-purpose zone.
Yeah, and then
They haven't really turned their minds to this type of zone, which is not urban.
and it seems to me the HPL then sends you down this ridiculous pathway to determine development capacity, which is utterly irrelevant.
That's right. That's right. And that's, of course, that's the way the planners. They've said, oh well, let's look at the exception, development capacity. Those criteria don't really fit here, but criterion C is relevant and supports the rezoning, so they've gone that way. Like I say, I think there's on balance a better interpretation than I just presented to you.
Right. So you avoid the A and B ridiculous assessment by saying it actually didn't intend you to consider this in the same sense.
Yes.
Of urban.
Yes, I say you don't even have to get to 3.64 because policy 5 says avoid urban rezoning of HPL. This ain't it. So that's the distinction. And super quickly, there's another avenue. We always
It's a wonderful thing.
yes, a smorgasbord of options. But the last one is it's simply a king salmon argument, really. You'll recall an avoid policy, Supreme Court thinking, oh, well, look, that doesn't mean, for an outstanding natural landscape on the coast, blinking lights or small fence lights, minor or mandatory effects can be enabled while still giving effect on the void policy. So the Supreme Court's always left a little bit of wriggle room there. And if we apply that in this context, you avoid urban rezoning of HPL, even if you think this is an urban rezoning, and if you think the 3.6 exclusion is met, then you can think about effects. And really, is there any loss of HPL here through this rezoning? There isn't, frankly, because it's a structural rezoning that effectively continues the current uses. Pito Whenua is always going to be that, the golf course and it's really it's a planning tool to rationalise and make more efficient the administration. It's not urbanising what's currently in productive use. There's no loss. Yeah.
I'd just set the panelists. Any questions on this before we move on?
You just on point D as well, you touched on it briefly. And you talked about the other aspect, which was that the upper treaty grounds is more akin to a Māori purpose zone.
Yes. Well, again, it's trying to really understand the words of the MPHPL and what it's getting at. So it's sort of so the definition of urban in that document, the National Planning Standard, Zone 8, Standard 8. And it's got the list of the special purpose zones. They've specifically excluded Māori purpose zone. It's trying to understand what the drafters are intending there. And clearly it's a slightly different point where they're saying, Māori utilising their land for kainga or for other whatever purposes, make sense for them culturally and commercially. That can be appropriate. That's exclusion. But then thinking about what this special purpose zoning is it certainly not like a hospital zone or a prison or or one of these urban zones. If anything, it's perhaps more akin to that. So I was trying to draw an loose analogy that way, but it's a bit more confusing. But so you don't need another option.
And only part of the site.
Yes, that's right.
Okay, we understand that.
Thank you. Thank you very much. And that's pretty much it from us lawyers then. There's a conclusion section that the Act sort of talked to really about our gratitude for being here and the process that's been undertaken today. And the really good progress that we've made on issues.
Thank you for providing that other pathway to it. So it's a difficult way that we all want to get through it. And we all want to do it the right way. And thank you for setting it out in a nicely detailed and understandable way. It's been quite helpful.
Thank you. So in legal terms, as Rochelle said, there are sort of three key outstanding issues that witnesses will talk to. We haven't addressed those in our submissions, but they really are technical planning matters, although we can get this hearing or beyond. We're in your hands. It's okay with you, sir. I'll ask Ben to emphasise any key points he thinks are useful for your consideration. There is a summary statement that we sent in on Friday. Okay, it's coming around now.
First of all, greetings to
Good afternoon.
fellow commissioners. And thank you to our legal team. And to my niece on my left-hand side here. And she has done as well. Just so, do I have to read this into the record, or can I take it that you're going to read it?
We haven't actually read this yet.
Okay,
So
I can cover key points rather than reading it verbatim.
we can read it again. So I'm in your hands.
Given that So that my presence here isn't superfluous. Background to where we're at the moment with the Waitangi National Trust. We've kind of got three paths ahead of us at the moment. And actually today is my second anniversary of having begun work there. And that's given me a bit of an in-depth understanding of the dilemma that the National Trust is in. Lord and Lady Bledisloe, as been mentioned a bit earlier, did a great thing for the country and bought the estate, bought the fairgrounds, and then they also bought the other land with the hope that over time that would self-sustain the fairgrounds itself, so that New Zealanders would have to pay a minimal amount of money, both for its upkeep and also to be able to enter it. Unfortunately, like all things over time, for a variety of reasons, the ability of the estate to provide sustenance for the treaty grounds itself, or Te Pito Whenua, as you have here, is pretty limited. If I start from the bridge, we've recently met with Becca. That bridge is going to have to be replaced within the next decade, probably closer to this side of the decade than later. So somewhere along the line, somebody is going to have to fork out maybe between $20 and $40 million. So come over that bridge, it's one lane during Waitangi, we have to close it. There is actually bigger, the surface has to be redone now. That is highly unstable. So we had that meeting about 4 weeks ago. Then you look to your right and you see the Copthorne, and that is meant to be a 4-star hotel, but we'll be lucky at times, but it's 2.5 3-star. It reminds me of going to Memphis and staying in the Holiday Inn and thinking Elvis walked on this couch. So that is the LIC, that particular hotel. There's been all kinds of discussions about what we need to do to upgrade, and you can kind of see why the reason doesn't, because the amount of people that come through the Bay of Islands at the moment is not high. So you're caught in a bit of a conundrum there. The boat club, we get about, we get in the high 20s, and then it originally maybe early 30,000 from there. And if you think about having a boat club right on the water, a beautiful place like that, and you're only getting that kind of money, it's not going to help run the business. And then you come up to Pito Whenua, and New Zealanders, rightfully so, because it's often seen as a Māori place, and in reference to being close to Māori purposes, but it's actually a place for all New Zealanders. And it's also seen as a Ngāpuhi place, but it is a place for all New Zealanders. And then people object quite often about why do I have to pay some money. The number of times my phone rings with one of my nieces asking me, there's 10 of us and we want to come in. It's like, you got to pay $35, because at the moment, we don't get, unlike Te Papa, you know all this anyway, but I'm not going to say it. We don't get the baseline funding. And everyone wants to have a hui there, and everyone wants a special rate because they're Ngāpuhi, and it's for the kaupapa. But what happens is a lot of our cafe runs at a loss, our events business runs at a loss. If you were running a commercial enterprise, you would probably shut the doors, or you'd close it down to maybe 2 days during the week and on the weekend. If we did that, we would be robbing New Zealanders of the opportunity, and also overseas people of the opportunity with us. We leave there, and we were talking about elite soils, that, you know, preserving the ability for future use of high value or elite soils is, no one's ever going to plant anything on that Pito Whenua site. There has been talk about putting a heritage vineyard in there because Busby had a vineyard there at one time. But that would not be a high commercial operation. It would probably be more around, go to the gift shop and take home a bottle of wine grown on the grounds. So, but then the rest of the estate, when you leave that, you've got the golf course. And, Ralph Johnson and I visited Arai Point not quite a fortnight ago to go and have a look at, because we brought colliers in to help us to look at what are the other economic activities we can do with the estate. Not different, but the estate. And we get around 70,000, between 50 and 70,000 a year on the golf course. When you go to Arai Point, one membership is 50,000 a year, plus 50,000 for your initial payment and 10,000 a year. So you can see the difference in the economics here. Obviously, we're never going to be able to do that, but in order for us to be able to attract, if you think of the hotel, the boat club, and the golf course, which are three operations that should be able to assist with increased income to sustain the organisation, all of them for various reasons, particularly given the legacy leases that we have prevent us from doing it. And then you've got the agricultural land, which is currently leased at $500 a hectare. And then you go into the forest. And the forest at the moment returns us around $120,000 to $140,000. So if you run all of that together, it's less than $1 million that we're making off all of the external assets that comprise the estate. So it may have worked in the past, it doesn't work now. And therefore, like this process that we're going through now has to, I think, as the chief executive, has to balance both the need to protect the heritage and the long-term value, cultural and social to New Zealanders in the future, but also allow enough room for us to be able to look at how do we self-sustain. That's option one. Option two, which we have tried a number of times even since I've been here, is to go cap and hand to the government, which we are in the process of doing, and say, please, can we have $2.5 to $3 million a year to continue to exist? And we are, Ralph and I have been working on that. I would give our chances of getting that, especially you guys will read the media, you know what the current accounts for the government are, and also a certain sentiment present around at this time. It's not that high. I hope I'm wrong and that I can come home one day on the plane and say peace in our time, but I'll hold my breath on it. So that's the situation with where we're at with these matters that are in here. In terms of wayfinding and signs, we don't want bus babies. Everything that we do there is about fitting in with the environment and the wairua of that particular place. And I can say the people that work on that site and also the trustees hold that paramount. In fact, sometimes trying to talk to them about economic matters is like talking to a brick. So the chances of us having garish signs all over the place are not high. So I do support Rochelle's proposition that at least 2 signs per activity. With the Hokainga, this is a really interesting one. Being Ngāti Kawa and Ngāti Rahiri, so it's almost like when these documents are put together, they freeze things in time. My great-grandmother's sister, Pātara Kaikohe, was the chairperson of the fundraising committee for the building of the marae waitangi. And but I could easily be both Ngāti Kawa and Ngāti Rahi. My grandmother is cited on the marae list of beneficiaries that were original people, as is Ngā Huias. But because I don't live here, I do not go to the events for Ngāti Rahi and Ngāti Kawa, because the proper way of thinking of these matters is you are the people in situ, you look after our affairs for us at that level, at the operational daily level. So we trust in you to take care of it. But when there is a big issue, then it's your job to pull all of us together and we all have to say, which is where there's two layers. There's Kaitiaki, but then there's the wider Ngāpuhi. Our daily relationship with Waitangi, because that's the other thing too, what's the entity you mean in these situations? Is it the marae committee, or is it like a hapu collective or whatever? So by and large, by instinct, you kind of know that's the leadership of the hapu, so we go over and we talk to those people. We work on a daily basis with the leadership of both of those hapu, of the ones named in here. When we're working towards the planning for the Waitangi Week, we have numerous discussions with them throughout that, of which Ngā Hui are wearing some of their other hats because Ngā Hui runs the forum over there. Is we do not embark on anything significant without having a discussion with the people at the marae. When we put our application in for regional infrastructure funding, we included $500,000 in our application to help them to finish the marae. And luckily we did that because they needed it right at the end. And we have an ongoing commitment to, if we benefit, they should as well. That includes employing a fair number of their whānau as well. So that is the level of our relationship with them. And in terms of archaeological work currently being undertaken on the estate, we have a pretty good relationship with Heritage New Zealand. Ralph and Nicole in particular work really closely with them when we were doing a car park or any other activity we intend to do on that, including right down to whether you're going to put coal in the ground or not. We seek the advice and support of Heritage New Zealand. So that's pretty much my evidence, and if you have any questions, please feel free.
Thank you very much. See.
One partai, my question is about events. You did touch on that in your evidence. We know some of the larger events, and there's also talk about kapahaka as well, the potential to host national events of that scale. Can you elaborate on?
Certainly. Again, just as everybody thinks they should come for free, everyone thinks they should have their event as well. and that's great. So they should, if they can afford it. We've had, last week we had the Pacific Island Police Conference there, which was a really major, the types of, we had Toi Ngāpuhi this year, there's a full range of different, and that includes companies and all kinds of things who want to have their event on site. And being able to keep the door open to that should be one of the main tenets of running the place, really, particularly on Pito Whenua as well. If you go to this year, there's the National Māori Housing Conference, which is coming up in the next few weeks. And then there is like the Carvers, Hui is going to be not long after that. And then once you start getting into the Waitangi event, and once upon a time, Waitangi was like 1 or 2 days, but now it gets bigger and bigger and bigger. On average, now it's about, might start on it's sometimes up to 6 days, and on each of those days, there could be 3 or 4 different events. So leaving some room in there for flexibility to be able to continue to that need is essential.
Yeah, you say at one stage in your evidence, you talk about doing some further work on signage provisions,
Yeah,
like internally or the like. Does that delay anything that we might be looking at in terms of signage?
I might ask Ralph to comment on that.
In short answer, no, it doesn't. It's a piece of ongoing work to do with, obviously, we're very centred on visitors of all sorts, both on Tipi Tupuna, but increasingly across our whole estate. And when you visit on Wednesday, we'll take you to the Haruru Falls track, which quite separate from the treaty grounds, actually received a huge number of visitors. So we're looking at an overall site revamp and refresh of our sign system. That encompasses wayfinding as well, which I'm sure you'll be aware is almost a science unto itself. And so as a site that's very long, a large number of roads, as well as a large number of tracks, we now need to develop a sign system and to incorporate, to be fair, what has grown up over a period of about 2 or 3 decades, quite a different set of intergenerational signs. So we're going to strip all of those back, produce a uniform system of signage that applies across the whole estate. And we're bringing a sign expert in, and we're working with him already. That's Chris Hay from Locales in Wellington, who's also worked on the Whakatane Hall sites, Russell, Rangihoa, Heritage Park. So that's the work that's currently underway. Yeah.
Okay.
And it certainly doesn't delay.
Yeah, I guess arguably it goes against the grain of the special zone idea to have a provision that, is very empirical measures relating to science. It's more subjective, perhaps. We're trying to tie it in, or someone's trying to tie it into so many signs, etc. No, that's fine. We'll wait to see what Ms. Jacobs has got to say about she identifies as the 4 issues in contention. It's come down to 4 from 9 originally. Okay, thanks. Thank you.
Yeah, no, thank you very much for your evidence, and I haven't got any further questions for you. That brings us-
I think, conscious that Ngahui is here as well, and if there are questions for her that you'd like to ask at this stage, feel free. And otherwise, Simon Cocker is the next.
So, Ms. Harawira, did you want to address us, or you just want to answer questions if we have any?
I'm here to answer questions. I did look at the report that reviewed my CVA, and there were a couple of concerns that so I'm happy to speak to that, but I'm also happy to just wait for questions if you guys have questions.
Okay, well, we'll probably, well, then we might have one for you now.
Okay.
Good. So earlier this morning, I did have one question about ahika, and that's somewhat being addressed by Ben, because Ngāpuhi, as you said, is a very large, even large area, and there's people that live there,
Yeah.
the ahika, and then a lot of people that come there periodically, and then other people like Ben are in leadership, Ngāpuhi, and you're all Whanaunga.
Yeah.
So in terms of your report, you did have the term uhainga that you used
Yeah.
to umbrella a number of those issues. Are you able to talk further on that?
Yeah, so tēnā koutou, e te whānau, Ngāhui a Harawira, and I whakapapa to all of Ngāpuhi from the Cape to Pukekohe. And yeah, honoured to be here today. In terms of, the term haukainga, I did specifically use that because Ngāpuhi haven't settled yet, and I'm mindful that this isn't a settlement conversation, and the document could be used in a settlement conversation, and the interest that Uncle Ben has already discussed of Te Whare Tapu o Ngāpuhi is in the Waitangi Treaty Grounds. It's not just for the ahika, as in the ones who live there. They do have a role of kaitiakitanga, and that's why there is an important duty that we have to ensure that we're continuing our communications with our whānau there. And it's why we have, I started the conversations with them about this project. And they've been very fruitful and very challenging. And yeah, it's been very helpful to work with them. But the use of the term haukainga was specifically to safeguard this proposal from impacting an issue like the settlement where it's really not it couldn't be in that realm. Yeah, really. Does that answer your part-time?
Just a supplementary question on page 25 of your evidence. It did note support for the subzones, but the haukainga also talked about resourcing for the next step.
Yeah.
From the district council.
Yeah.
How do you see there's not more narrative around there apart from that sort of statement?
Yeah.
Do you have any narrative around that?
Yeah, sure.
As one of the paragraphs?
So that was one of the specific statements that was made by the haukainga, the Anka, in particular in terms of the PDP planning processes for resource consenting and what were their considerations that were important to them when there were resource consents being granted in their area. So one of the points that they were making in these submissions, and these are not lay people, you know, this is like Merata Kafaru, who's very intelligent and very celebrated in her realm. They've already had the conversation, they've already had the wānanga, they've already, you know, this would have taken 3 to 6 months for them to put the submission together. So they've already done a lot of the mahi that we're asking of them. And so they've come to the conclusion that, yes, these are our preferences, but actually some of the barriers to us being able to participate in these processes is that we aren't being resourced. And that's why I highlighted it in the submission, because when you look at the hapu hui that we had online, one of the main things that came from my late auntie Hine Whare, and I remember this clearly now because it ended up being the last conversation I ever had with her, was that we've had these conversations so much. We've been talking about the sites of significance, we've been talking about what's important to us, our aspirations, and it's already been recorded. And there's this whakao that everyone just wants a mihi kehi kai, and then we've ticked the box, but actually what she challenged me to do was to go away and find the information that was already out there, find the research that had already been done, the Māori expertise that had already been done in the situation, and that's essentially why I took the approach of bringing in the Waitangi Tribunal reports, the submissions from the PDP hearings, because they were directly related to the PDP, the draft PDP, which is what we're discussing today. Yeah. Yeah, kia ora, kia ora. I think if I can, because there was just kind of conversation about, like maybe a concern maybe about relying too much on the literature. So the tikanga whakahaere was specifically based off the whare tiriti model that was built by Whatarangi Winiata. And I've done a lot of research with Kathy Irwin, who is doing Te Whaitua o Kaipara, or not Kaipara, Kapiti. And they're talking about the relationship between the Greater Regional Wellington Council and the Raukawa Marae, and that hasn't been formalised yet. So we could have actually utilised that in this proceeding, but because it hasn't been formalised, we can't depend on it today. So we look at things like Ani Makairi, who's already discussed governance, Sharon Toy, who's looked at mana tuku iho and governance. We look at Mason Jerry, Jamie Tuta, and so there's, again, listening to those challenges that I got at that hapu hui, get out there and find the information that's already out there and come back to us with a plan. So that's why this CBA is very literature heavy, because that was the grounding that I got at that hui. Yeah.
Well, it certainly is comprehensive. So thank you very much for that effort. That's where it's certainly helped. I mean, there's been a tremendous amount of evidence presented more diligently this year. So whilst you've given us a lot to read, it's really, really good to have that, which we'll go back to. I think, so I think in terms of those questions, I think we're ready for your next witness.
Great, thank you. So Simon is the landscape architect. There are the presentation, I think, isn't there, Simon, of some visuals that were printed on. Yes, how do we follow it?
I'll just start sharing and start with.
And Simon's also prepared a summary statement, which he's tabled today, actually, with some comments.
Yeah,
available today.
Magically appeared on my desk.
Well,
Good afternoon, Kaikohe. Welcome. Thank you. You're in your hands.
Well, my visuals don't directly relate to what I'm going to be talking about, but they're more a background to my evidence in chief, and they show the key aspects of what I was talking about in my evidence in terms of my landscape assessment, looking at the sensitivities of the landscape and coming down to the zoning. But they're there if you want to ask questions, but otherwise I'll just talk to my summary statement. My name is Simon Cocker. I've prepared primary and rebuttal evidence on behalf of Waitangi Limited in relation to its submission of the proposed Far North District Plan. Waitangi Limited's submission relates solely to the Waitangi National Trust estate, contains the historic Waitangi Treaty Grounds, and it is responsible for managing the day-to-day operations of the estate. Primary evidence sets out my involvement in advising Waitangi Limited on the Far North District Council's plan review, including my involvement in preparing the assessment of landscape effects for the Waitangi Estate Special Purpose Zone. Assisting Michelle Jacobs, Waitangi Limited's consultant planner, in preparing the draft of the REZ provisions. Today, I will provide a summary of my response to matters raised in the Council's Section 42A report for the Waitangi Estates Special Purpose Zone that are relevant to my expertise. First issue relates to the activity status for non-compliance, NFLR 1. Based on my experience as a member of the team which undertook the Northland Mapping Project, that was to identify the outstanding natural landscapes in Northland for the Regional Council, the treaty grounds were identified as an ONL due to its cultural and historic values. In my view, if the Waitangi landscape, as overlain by the ONL overlay, were to be similarly developed, but devoid of its historic and cultural associations, it would not be identified as an ONL. That's not to say that the treaty grounds will have landscape or visual sensitivities. It's just that there's some areas have higher sensitivity, some areas have a lower sensitivity. It's a working landscape as well as being a cultural landscape. So there's workshops and there's storage areas, but those are out the back of the house and out of the way and hidden. So in my view, I concur with Ms. Jacobs' view that the matters key to the values of the Waitangi ONL are best given effect through the objectives and policies which relate specifically to the ONL as a discretionary activity. And this is an example. I was involved in the site planning and the mitigation and consent application for the Māori Battalion Museum, Aotearoa. And through that consent process, we were able to integrate that building really might be very successfully into the landscape there, so that it does not impact on the visual values or the sensitivities associated with the treaty ground. Moving on to signs in the WEZ. Under the view that allowing 2 signs per activity is appropriate. As a tourist venue with a variety of elements, built natural and cultural and spiritual, signage is needed to address both directional and interpretive themes. However, these signs will, by their very nature being predominantly internal to the site and will not be readily visible from external locations. Issue 3, assessment criteria. In her memo dated the 17th of June 2025, regarding limited submission, Ms. Absalom suggests that this criterion should be included in the WEZ R1 criteria. I agree that criteria should be criteria. Having reproduced it in my statement. Issue 4, WEZ S2, where this applies to the Whakanga tourism subzone. MCK identified that it was assumed that this was a potential typographical error in rule WEZ S2 relating to the tourism subzone, noting that MCK considered bulletin should read 55 degrees at 2 meters above ground level, as is usually prescribed for southern orientation boundaries. Now, this is I've suggested a more more onerous restriction due to the sensitivity of the treaty grounds themselves, and the potential for visual intrusion and dominance generated by built form within perhaps neighbouring tourism subzone. So I believe that more stringent control is appropriate in this particular boundary. It's my summary statement. If you have any questions, I'm happy to.
Great, thank you.
Just on the question of signs, Simon, you say allowing 2 signs per activity is appropriate. I mean, Michelle set out in her evidence, she's differentiated between I think she said 1 sign announcing the activity and the second sign being a directional sign. Do you see that distinction, that the 2 signs would have those specific purposes, or would be more general?
I think generally speaking that would be the case. I mean, as a tourism attraction, you have directional signs. It's also interpretive signs. I mean, the whole point of and is that it's a cultural and historic. So you're going to require these interpretive signs and as well as directional signs.
So you would just see 2 signs per site. Interesting, given the nature of the activity on the site, you know, the wider activity on the site. That, you know, I'm almost amused by some of the restrictions on the provisions that, you know, relates to the signs one. But as I say, I've been sitting and waiting for Rochelle's evidence.
I visited the treaty grounds this morning on a different matter, and I was specifically looking at the signs on the way in, and the way the signage has been treated to date, despite the earlier talk before about the intergenerational signage, the signage is very discreet and as you would expect in a high profile venue, which has the treaty grounds.
Yeah, thanks.
Yeah, I mean, one of the, this is possibly not a question just for you. It seems to me that when we're talking about signage, are we also talking about interpretation? Because, you know, a preeminent historical site and our preeminent site, so it deserves some interpretation. I wouldn't mind hearing you sort of address that in particular, and how you think the provision, and sort of thinking as a tourist, and I'm one of these guys that's gravitate towards interpretation. I like a story being told.
Yeah.
You know, nice
That's
pictures.
where that difference kind of comes into visible beyond the estate, and that wording that would include, because you do need a lot of those panel interpretation type signage, and a lot of that on the estate can't actually be seen outside of the estate, especially when it's on the whenua, because it's surrounded by trees, other vegetation, or just topography.
Yeah.
So we don't want all of that sort of signs to be captured, as is currently in the operative district plan. That definition of signage, which only includes signs which are visible from a public place.
And so when we think about bad signage, we usually tend to think of third party buildings. Now, obviously, they're off the menu.
Exactly.
There's not going to be any Heineken signs.
No,
No.
and one of the provisions that we've included in signs is that they must relate to the activity on the site.
Yes, so there's no interest, well, there's no intent on behalf of the property to make an income of sign.
No,
So
No.
we're talking about interpretation directional,
correct.
that's pretty much it.
And just for announcing that you're at the activity that you're being directed to.
Right, okay, so those are arrival, directional, and
And
interpretation.
Yes, interpretation and formative.
And that covers that.
I know like there is an exemption in there for Heritage New Zealand type signs, for your general historic type items and objects that you're viewing, but Waitangi doesn't necessarily have that because they are Waitangi branded signs. So they don't they're not afforded the same exemption as Heritage New Zealand, whereas they are kind of doing the same.
I just have one question for Mr. Cocker. I think looking back on the previous panels we had for heights of different activities on the grounds, I think that was one of the issues that we talked about in previous hearings, but in terms of the zoning that's been requested and why it's different and why it's so significant and special. In terms of your evidence here, it doesn't talk about that because that's not an issue of contention. But I guess given that it is such a special landscape and that there's significant do you have any other narrative around that relating to the tourism zone here, the tourism subzone, as compared to the treaty grounds?
So I'm not quite sure.
I think you gave
Oh, yeah. So that was my last point about the submission.
yes.
Well, because you got the tourism subzone immediately adjoining the southern boundary of development, military grounds, this I think buildings it's 10 meters maximum.
Yeah, so we've basically used the mixed use zone provisions for the tourism subzone. But there are a few little changes such as in terms of the sunlight restriction. That is at it's proposed to be 35 degrees rather than 55, just to give that added separation.
Because if you're providing for a building of 10 meters high, because within the potholed area, there is the potential, if it was close to the boundary, that would impact on the visual amenity of the lower treaty grounds. So I'm suggesting that it's restrictive recession plane, which would push the buildings back or keep them down lower, and to join the zone.
There's also a landscaping rule that we've proposed to really protect the view shaft as you come across the bridge and navigate towards the treaty grounds, because you've got the platforms sides there. We've included a provision that protects all that vegetation between the Cotswold and the road to make sure that it's kind of screened from view.
Looking at the wider amenity and the character, distinct character. Really special. Trying to protect those elements.
The last building that you did, I think, I remember from the evidence was 10 meters high. Was it 9 meters high for the museum?
And
It's 9.
9 points.
So the existing built structures there are similar height to what is
Is proposed. Yeah.
Okay, thank you very much, Mr. Cocker.
Thank you. Well, finally then, Michelle will, focus in on those points of contention. That last witness. And then, sir, did you say that the council team will have the opportunity?
I'll ask the council if they've got any questions of clarification that they'd like to direct through us. I think that's, and then we'll probably have a break from afternoon tea, and we'll welcome you to stay and have a cup of tea and scone with us. Yeah, 10, 20 minutes time. And then we have Heritage New Zealand presenting. Are they in person or online?
They're just directly.
Oh, there it is. Hello, that's amazing. Well, you're more than welcome to join us for afternoon tea. So.
Thank you.
If it helps to follow what I'm reading out, I've basically taken my summary evidence and included it as my slide notes, so feel free to follow that if you like.
Okay.
Might be you manually, okay?
Oh, that's okay.
Okay, the impermeable surface rule issue only applies to the Whakapanga tourism subzone, where the proposed standards were changing as a result of recommended amendments to the urban zone. Through consultation with Cognizant Corporation Limited, who own and operate Millennium and Copthorne Hotels New Zealand, Waitangi Limited proposed a 70% site coverage standard to council section 42 report writer that did not require engineering input. In response, the council officer offered two alternative options in the section 42A report. Option 1, assume the new standard being applied to the mixed use zone, or option 2, allow a nominal increase of 5% to the existing site coverage. Following discussions, MCK have accepted option 1. Regarding
So can we deal with those one at a time? Otherwise you're going to confuse us.
no worries.
So that one's clear. That
Yes,
one's-
that one
there's
we're-
agreement.
Yep, we've answered basically
That's
what
what I
42A asking, so
Yeah.
yeah, that one's satisfied.
Yeah, so the lens we'd like you to potentially adopt is things that are still in contention.
Yes. So this is where I've responded in my rebuttal evidence on those.
But yes, as Commissioner Watson said, if you agree with
The
the
council.
report.
Yeah.
Then we're not going to.
Yeah.
Well on that, unless we think you're both wrong.
And then just quickly, the matter relating to exemptions for buildings and structures. The 42A report writer pushed back on that, and we've decided not to. NFL R1. Waitangi Limited has sought to reduce the permitted standard for buildings in the Te Whenua Treaty Ground subzone from 50 square metres down to 30 square metres. This reduction was intended to enforce a more restrictive standard for built development on the upper treaty ground. However, this 30 square metre standard has been removed from council's recommended west provision, included in Appendix 3 of the Section 42A report. I discussed this with Ms. Lynette Morgan, and it appears that this deletion has come about due to a miscommunication between us and was subsequently missed by me when referring my rebuttal evidence. Ms. Morgan has clarified that council's stance is that the 30 square metre standard should not apply. Waitangi Limited's stance is that this should remain as a permitted standard within WES S4, so that the standard is located within the special purpose zone rules rather than in the general NFL R1 rule. The activity status for buildings exceeding 30 square metres would be restricted discretionary under WES S4. In NFL R1, Waitangi Limited seeks that the activity status for buildings and structure development exceeding 50 square metres on the Te Whenua Treaty Ground subzone change from non-compliant to discretionary. The main reasons for seeking the 30 square metre permitted standard is that the upper treaty grounds have high historical importance. This restriction provides additional protections, including requiring consideration of the WES objectives and policies which have been developed to protect historic heritage within the Te Pito Whenua Treaty Ground subzone. The proposed amendment to NFL R1 activity status aligns with policy planning guidance as detailed within my rebuttal evidence. I note that the Te Pito Whenua Treaty Ground subzone and the outstanding natural landscape overlay generally cover the same geographical area, with the exception of the southern boundary where the Te Pito Whenua subzone extends to the cadastral boundary. Some areas of the Te Pito Whenua Treaty Ground subzone have higher value than others, meaning that built development on the upper treaty grounds would be subject to different expectations compared to development occurring near the old bowling club, where there is very little public viewing and no view shafts to the historic buildings and objects. A discretionary activity status enables those areas with lesser value to be developed or upgraded without requiring the gateway tests to be satisfied under a non-complying activity status, while at the same time providing sufficient protection mechanisms to prevent incompatible development in areas of higher value. The mapped area of outstanding natural landscape, as detailed by Mr. Cocker, holds outstanding value due to those historic features and what they represent to the people of New Zealand, rather than because of its naturalness, which is generally the basis for all other mapped outstanding natural landscapes. Special purpose zone objectives and policies have been developed to protect and enhance this area, which is why it can be treated differently from the general district-wide rules. Those objectives and policies recognise the existing operations at the site and the need for appropriate built development and structures to support its operational requirements. Obtaining resource consent for an operational need should be considered a routine aspect of site management rather than an exceptional circumstance as implied by a non-compliant activity status.
So the business is 30 square metres as compared to 50.
So what,
You're
yeah,
wanting to have a stricter control on this.
I'm looking for a stricter control. So right at the moment, it's governed by the NFL R1 rule, outstanding landscapes, which comes in at 50 square metres. That's the most recent recommendation.
Understand.
What we're looking for is a 30 square metre standard because we're recognising how important those upper treaty grounds are.
30 per metre,
30 square metres per
per
metre.
metre, and that discretionary after 30.
And then that would be restricted discretionary after 30 in the WES provisions. But because the outstanding natural landscape rules are general and they would also apply, that would kick in at 50. So we're not proposing to change that. What we're proposing is to change the activity status. So at the moment, anything over and above 50, because it's in the coastal environment as well, goes directly to a non-compliant activity. But what we're saying is that the treaty grounds can be treated differently because it's a special purpose zone. And the reason for it being an outstanding natural landscape is because of those historic buildings and objects and the fact that people associate that site with the historic events that happen there. So it's more the built development and those historical matters which make it outstanding. And those matters are covered by our objectives and policies. And so we're asking, because it's not a pristine natural environment, that it be treated as a discretionary activity. Because there are areas within Te Pito Whenua which don't have as high a value as the upper treaty grounds, which is those areas that are outstanding. And we want to still enable some development, or, you know, there might be a health and safety reason or an office building that needs to go on.
And I think you're also saying is they would be something like directive objectives and
Correct.
policies.
In the special purpose zone.
And you're saying that's more in line with modern planning practice rather than deferring to non-complying activity with the stringent exception provisions.
Correct.
You've got to-
It can be hard to meet if
It can be, and it may be the difference between gaining consent for something that has an operational need and not.
And Mr. Crawford addressed that in his evidence,
Yes.
and also there's a further operational layout of the board and the processes in collaboration with Heritage New Zealand to decide
There's all
the
of
other
this.
sides don't have.
Correct.
So you're wanting us to have a look then at those directly.
Yes,
See if we agree
correct.
with you. I'm assuming there's a few points in there.
But also some more enabling ones as well.
Yeah. I see. Okay, I have a follow-up. So 30 permitted,
30 permitted and rather than change NFL,
Yep.
the general rule, we're proposing to put that in standard S4
so
instead.
permitted 30 to 50,
Would be RDA.
RDA, and then
Then the NFL R1 rule would kick in, what at 50, which at the moment makes it go non-compliant. We're asking that go discretion instead.
so you're asking for the precinct provisions to govern all of those activity states. 30 permitted, 30 to 50 RDA, and then 50 plus.
Discretionary. Yeah.
Understanding.
Because we still want,
And all within the precinct provisions.
Any other questions on that one?
Is that the, yeah,
That's that
thank
one,
you,
actually.
that's that one?
Yep.
Got a couple more, go ahead.
Science.
Yeah.
It has been recommended by council officers in the section 42A report that a new PER1 be added to sign R15, which requires a sign to meet setback and sunlight zone standards, with the exception of road setback. However, as a sign already meets the definition of a structure under the proposed district plan, compliance with these rules is already required. To address this, exemptions to the relevant setback and sunlight standards, WES S2 and WES F3 have been included, that only the sign rule applies and there's no conflict between the rules regarding road boundary setback. Regarding sign S3, which controls the maximum number of signs on a site, council officers in Waitangi Limited have agreed that sign limits for signs visible beyond the estate be on a per activity basis, rather than imposing the standard total sign area restriction, which for the estate is completely unworkable. However, the section 42A writer's stance is that one sign per activity is sufficient to avoid any visual amenity concerns. Waitangi Limited seeks that the permitted standard enable 2 signs per activity, as one directional sign and one sign announcing the activity are required. It is both my opinion and the opinion of Mr. Cocker that the combination of sign standards 1 to 5 and the ongoing management of the site by the Waitangi National Trust Board and Waitangi Limited, in accordance with the WES provisions, will ensure that signs are well considered and do not result in any adverse visual effects, as is currently the case. That's how it operates under the operative district plan. Waitangi is a site where heritage is of utmost consideration. The type of signage used will not detract from the heritage elements, nor will there be sign clutter visible. It's just not one of those sites where this type of activity would be enabled. Development on the site is well considered and thought out, including the location and design of signage. What Waitangi Limited is seeking has very little risk of any adverse effect and is already minor, with only 2 signs per activity being sought as a permitted activity. Permitted standard only allowing for 1 sign is unworkable and would result in costly consenting of any future activities, including the signage refresh that we've been discussing earlier.
So, you might look at me, but understandably. So the 2 signs, would you see the 2 signs being restricted to one being an identification sign and one being a directional sign?
I just want to specifically restrict them as such, because you might need 2 directional type signs for that activity. And then when you actually get to the activity, you might have the signage, but it might not be visible to the public. So I didn't want to specify that's what it needs to be.
And so that'd only be 2 signs that are visible from beyond the treaty grounds.
Or
Yeah.
beyond, from a
Yes.
public place. So
Yeah.
that could be the coast, that could be Te Karuwha Parade, which goes as far as the Copthorne entrance and Haruru Falls Road.
And you're happy with the term public place?
It's trying to find something, I know, it's trying to find a standard that would be workable because the proposed standards were just not workable. So the wording I came up with is actually used in the conservation zone or open space zone for signage. So I've kind of treated it in the same way. But yes, just trying to find something that was going to be workable, but still have some standards in place. That's kind of what I've come up with.
So we're winding up to the tougher one of temporary activity.
Yes.
I'll segue there, Commissioner. Temporary activities.
Yes, next. Two issues have been identified with this rule by Waitangi Limited and the council officers. Firstly, PER2, which governs hours of operation. The Section 42A report had recommended a 6:30 AM start time. However, Waitangi Limited have requested a 5 AM start time to allow for performed services. The definition of temporary events includes temporary car parking activities associated with an event. And as temporary car parking is located across all subzones, this exemption has been applied across the further amendment to the rule was sought for Waitangi Day celebrations, as temporary car parking starts at 3 AM, given the number of people visiting the site. The second issue is the number of temporary events being enabled as a permitted activity on Te Pita Whenua. Given the definition of a temporary event, this captures a wide range of activities, from Waitangi Day celebrations through to corporate events, functions, art exhibitions, filming, Kaikohe, and public gatherings, including visits from dignitaries. As the majority of events on the treaty grounds have already been consented through development of event spaces within the museums and within the permanent marquee, there is concern that this rule will capture events such as Kaikohe or public gatherings, which due to population growth may exceed any existing use rates. These types of activities are fundamental to the purpose and significance of the site. For this reason, events of this nature should not require a resource consent. Waitangi Limited, therefore seeking that there be no restriction on the number of temporary events that can be held on the treaty ground.
You don't say that from a planning point of view, or as a planner, that you support it. Take a view.
That is my view, that I would support that. And that's largely because of how the site is set up. So when you have a temporary event, the kind of effects that you're looking at are car parking, which they provide internally on the estate, and noise. And because of where the treaty grounds is situated, it's kind of away from everyone else. And so, I mean, I did a resource consent for 6 concert events on the sports ground. And the acoustic reporting that we had back on that showed that there wouldn't be any adverse noise effects. And the treaty grounds is even further away from that. So.
Yeah, I guess it's interesting because I don't think anybody would deny, the opportunity for temporary events as part of, the Waitangi estate, or particularly Waitangi Day celebration. Right? Then that has to be countered with the public expectation that there be some form of control over it. But I don't know that it's a temporary event. I mean, Waitangi Day celebrations are sort of enshrined in New Zealand history and New Zealand culture and the like, and it's almost like, it's
a recurring event.
Yeah, yeah, maybe that's what we're looking for, because I mean, when does a temporary event become a permanent event? I mean, you start putting all these restrictions on, as various district plans do. What it really is, it becomes a bit of a nonsense, quite frankly.
Yeah, it's just, I just looked at the definition and I'm like, this is going to capture so many things that they are already doing on the site.
That was going to be my question too. I'm looking at the definition of temporary events, temporary activities. I'm know that definition's possibly going to have a hearing. 17. We'll be looking at definitions, but you know, it's what it is now. It doesn't actually refer to number of days. And there are other definitions in other district plans that sort of say anything duration of X to Y, you know, they give you like a number of days. That would actually be quite helpful. I'm just sort of wondering, would Waitangi Limited be interested in possibly offering a qualifier as to what a temporary event would be in terms of duration?
Number of
Could
days.
do. I mean, the issue will be that you've got Waitangi Day, which is basically Waitangi Week.
Yeah.
And
But
then
if you have
you've got,
anything that goes longer than a week.
then you've got all the other events which are like, they could be, you know, a hearing, for example, where that might take place over like 3-4 days. Or it might be a conference, similar, or it might be just a 1-day art exhibition. There's just a number of things that happen.
So, I mean, because here's the thing is you want an unlimited number of things. And where I think the reporting office is getting a little bit sort of twitchy is that there's no limit to how many days a temporary event can be.
Yeah.
It's sort of like the situation where if everything's temporary, nothing's temporary.
Yeah.
And I'm sort of wondering, is the issue, if you're able to accept that a temporary event would be X duration, then maybe an unlimited number, or at least a really enabling number, could be more palatable.
Yeah, I agree.
Does that potentially get us somewhere?
I think so. I mean, if
And
we
you could
had,
even, sorry to interrupt, but you could sort of go, right, how many events do you think we need to go for a week?
Yeah. You
could sort of go, right, when it comes to this precinct, X number, you could have X number of events that go up to a week.
Yeah.
Whatever it is. And then you go, well, then the next level of bring is like 2 or 3 days. How many of those do you think? Do you need to have a cap on that or not? And then you've got things that would just go for a day or half a day or something like that. And maybe those could be potentially as long as they're, you know, defined.
yes,
And maybe so you're dealing with the effect by defining the duration. And if you've got the duration sorted out, you probably don't need to be so obsessed with the number.
yeah. The main one would be Waitangi Week.
Yeah.
And then others, I think Ralph might be able to
Why
correct
don't
me
you
on
just
that.
deal with that as an exception?
Yeah, I think
That's-
With the exception of Waitangi Week, which is not, as Commissioner Watson says, it's not really a temporary activity. It's a permanently recurring activity. So you just
yeah,
plonk that over there right away. And you're dealing with everything else, aren't you?
Yeah.
It's a kapahaka or Pacific Island Police conference.
yeah. I think should be
Which one, we're trying to help?
Can I assist you, Mr. Chair? In the activity status, P1, it talks about a temporary activity doesn't exclude, or I'll read it to you, the site is not used for more than 2 temporary activities per calendar year, and each event does not exceed 2 consecutive days, excluding the Waitangi estate, where a maximum of 5 events are allowed on the treated grounds. Yeah, so
They're already excluded.
they are, and that is reflected further when
General standard for temporary activities is 2 days.
So if you knew a temporary activity had a limited duration on it, would you feel more comfortable about restricting the number?
I wouldn't.
That's what it comes down to, doesn't it?
I'd like to take some time to think about that, but in the other hearing, there was some discussion between Ms. Jacobs and I, particularly around Waitangi Day, in terms of extending it. And I think that I'd like to take some time to think about that. The issue, I think, in terms of any temporary activity is what we were talking about earlier this morning. Any activity is to limit the effects of the temporary activity.
But you know, what Ms. Jacobs just told us, in terms of those effects are normally car parking and noise. And so we've got some evidence presented today that sort of says by your like I think what you're saying is that you tested noise, and it's because of the separation distance to those affected receivers that mitigates that to a certain extent. And I think you're saying to a large extent. And car parking, what was the car parking argument?
Well, car parking is provided for on the
Yeah.
estate,
It's provided.
so it's all
for the same.
internal.
So when I accept the principle of like, we've got, temporary activities can lead to a number of adverse effects. And this one, other adverse effects should we be mindful if we were going to restrict the number?
Well, what's an option to consider would be having no temporary activities as part of the Waitangi estate. Why have the activity provision when it's inherent in what they do there? That there are
Mr. Chair. Mr. Chair, I think I'd acknowledge the Commissioner's point there, and I would note that this is not a framework that Council has come up with. This is a result of submission from Waitangi Limited, and that we are trying to work with to try and get the best we can. I think it's fair to say that Council officers do not feel that perhaps they've got the optimum that they've requested or required. And I guess we're trying to make the best of what's actually in front of us. This issue, as noted, was raised as part of the temporary activities and signs provisions at those hearings. So this is not new. I would certainly point out as part of the signs, section 42A, that specific signs around wayfinding and interpretation signs were actually prompted to Waitangi to come up with some rules as part of their special purpose zone, in which case they haven't. And certainly our interpretation around activities is different to perhaps Waitangi's activities. So, I mean, I just note while the provisions might seem, or the responses through the section 42A might seem a little rigid, we're dealing with what we're dealing with, sir, to try and get an overall balance here. I'd also note that some of the matters that were identified as potential temporary activities, a conference, I certainly wouldn't call a conference temporary activity. They've talked about art stores, art galleries, all that sort of bits and pieces through here that are actually in their Waitangi commercial activities definition that would also not be considered temporary activities as well. It's a very difficult beast to wrangle, sir, with the information that we've got in front of us.
I thought you'd been very quiet, Mr. Because I was waiting for you to come on the screen much earlier.
So well, I would suggest, Mr. Chair, that the panel might wish to consider a direction, at least around to Waitangi Limited, around temporary, wayfinding and directional signs. I think that's certainly not what we're talking about. We've sent the message, it hasn't been picked up. I think that's causing some conflict. I think it might be useful to you to direct some information on that matter as well, noting the other things you've probably directed that on. I would also note that what we're not talking about here is a clearly defined number of activities. If you have a look at the framework, and we've talked about this morning, there are a number of like we've already got, I guess, independent operators on the estate. So this is not to say that Waitangi will be the people operating these businesses. These could be leasehold arrangements. These could be private businesses who might want to operate on the site. So I don't think we can make that assumption. Certainly we haven't heard any statements to the contrary. So we've got an uncontrolled number of activities, and sometimes with a limited size. So that is a factor when you talk about those peripheral effects that you'd need to take into account. We certainly don't know where those are. With the point around regarding Te Pito Whenua, yeah, look, some of this information, certainly the cascade, I understand we haven't seen before, so this is new evidence before us today. So Council hasn't considered that approach. Certainly what I would note again, though, is that as we spoke about this morning, there is a limit on size to those buildings. We don't have necessarily a limit on the number of them or the scale of any business commercial that operates, particularly in Te Pito Whenua, which is perhaps the most, I guess, sensitive on the site, sensitive part of the site. So look, it's fair to say we are still quite far apart on some of these issues, and perhaps would really appreciate some further detail to get this across the line in a way that we're all happy with.
I've got a question, relating to the temporary activities. Given the treaty grounds aren't just significant for Ngāpuhi, but, you know,
Yeah.
for all of Māori in New Zealand and also Pākehā as well, for the whole nation. In terms of Ben and Nahuia, the activities, some of those activities on the slide there from, Mrs. Jacobs, can you just bring that up again? Some of those were of a cultural nature.
Yep.
But also they're an event in the same. It talked about hikoi, iwi cheers, which may be cultural, also with hui of a conference nature. Can you give some narrative around those temporary activities? And I guess what we're hearing from staff around putting limitations, or potentially putting limitations around those, and how that might work in practice, then for the treaty grounds. I don't know if the other commissioners have been there on Waitangi Day, but how the cars come from the back through Hurudu, as well as no cars being able to go over the bridge, and how it's more probably of a regional approach to traffic management and parking. Have you been to the Waitangi Day at the dawn ceremony?
Yeah. I would have thought, I do agree with the bit about conferences sort of don't really represent a temporary event or temporary activity, but like the upcoming housing expo, it's going to have a marquee out on the sports field, and marquee, portaloos, the whole setup. So whenever people have those events, or there's the hot rod event that comes not long after Waitangi, cruising the bays, that is a marquee and band and all that kind of thing. What else is there? When Toi Ngāpuhi was on, they had the marquee and pretty much spread right out around the place. That's just this year alone. So, what else are we going to get out there? Pretty much that's the kind of vein that you're dealing with going forward.
Yeah, I think also there's nowhere else in Te Hiku o Tika that has the cultural capacity to host a lot of these events. Like just having a pōhuri for the kingitanga. There's nowhere that can house it. There's Te Matatini coming, there's nowhere that can house it. You know, Paia having the most restaurants and bars in Te Hiku o Tika is a huge factor for logistics. And it is a regional kind of issue when we're looking at the scale of the traffic management on Waitangi Week. And that's why we look at the council to assist with, you know, our haukainga deliberations, because it is going to have a regional wide impact economically, culturally, yeah.
So I guess following on that vein, my fellow commissioner said, you know, how about no temporary activity rule within that zone? What's your response to that? Is it, you talked about significance regionally, do you have any further narrative around that?
And then just it would be temporary events are excluded on the Waitangi estate, or just anywhere?
Well,
Because really
I
it's-
would ask the question to
Yeah.
both.
It's really to put the whenua, because that is your event, that's your main event state.
You wouldn't have it on the farmland, would you?
No.
No, but in saying that, you have the temporary car parking, which is defined as a temporary activity, which does occur on the remaining state.
Yeah, okay.
We also have the all the people that use the slipway, in summer, that's just backed up for miles. So, and that's not even for a major event. So as soon as summer comes, all the trailers are parked up there. We mow the lawn and we don't charge anybody for it because it's a, you know, public service, but we could do that.
I'd like to move this forward. And thanks, Mr. Whittle, for that clarification from council officers. It seems to me that there may be some things on this, like this list, which actually aren't temporary events and are provided for by other provisions. I think Mr. Whittle was suggesting that. And then we also have the other thing, but it does exclude. So maybe it might be an opportunity to get a closer look as to what might fall under other activities, commercial activities. It seems to me that like the first three on your list probably aren't temporary activities. They are regular events.
Yeah.
Then you say corporate events, yeah, that's probably temporary art exhibitions. And those other ones, they seem quite genuine. So it seems to me, I think we're sort of grappling with the animal first.
Yeah.
And maybe there's a few things in there that shouldn't be. And we sort of really want to be informed as to what actually are, what really are going to be up to temporary events that you're going to want to provide for and be allowed to provide for, and what the duration of the associated. Yeah, and then I think both council and Subtitles can have a think about what the effects is that do actually need to be managed, and still that happens. I want to have a think about whether that turns into a direction or whether we just sort of have another chat about this tomorrow once we do all the evidence. I certainly want to think about it overnight myself. But
I don't mind sitting down with Linda again as
yeah, I
well.
was going to say, notwithstanding anything that we say or do, we want to encourage the conversation. I think probably a little bit of clarification might help the issue. What we're wrestling with.
And I think as the chair suggesting, maybe a dual approach. Maybe at Waitangi, there's certain events that happen at Waitangi and are there. There's the other events that still need to be managed in some way, which are the temporary events, the ones that we're looking at.
It seems to me that Waitangi Day and Anglo Day and Matariki things are going to happen in those treaty grounds every
And
year.
they're recurring.
So that should be sort of just off the list straight away. We all know what they are.
Yeah.
And we all know how long they go for, and they're managed.
Yeah.
So I'm assuming we're talking about the other things, the other unknown list of things that could end up becoming a whole host of things that potentially get out of control. I think that's fair.
Mr. Chair, I think it's important, the definition and the rules and the chapter also talks about, and they may restrict public access to public places. And you may recall this morning that Mr. Witham talked about the trail that runs right through the treaty grounds. So that is something to take into account, and I will address that further, or he will address that further in the right reply, because that's quite important.
Yeah, that's cool. We're not trying to pin anybody down now. I think we're just trying to assist the clarification of the issue.
What is the question that I'll be asking as well is in terms of cultural gatherings around how that fits in with the definition and then regionally significant, I would call it regionally significant infrastructure, both for Ngāpuhi and for the Kaikohe. So our council advisor as well, Julian, who may sort of have views on that.
Sorry, through the chair, I didn't quite catch that. Was there a suggestion that it meets the RPS definition of significant infrastructure?
So my question was around the cultural gatherings and getting direction from the submitters as well as from council officers around what that means in terms of culturally significant infrastructure for the region and the type of functions and it's even been identified Kaikohe and those types of events that may occur on the site and how that falls within definitions.
Yeah, look, Mr. Chair, I would suggest that council aren't best placed to respond to that without something being put to us on that.
And if I can add this, I think there's been excellent food for thought, many of us to go away and work with. We can do that reasonably properly. I don't know if there's a direction either, but we can, Rochelle can bring up the issues, talk to Ms. Morgan as need be, and submit some further material for consideration within a certain time.
Yeah.
Probably not tomorrow.
Look, I'd like to think about that further and think about how we enable this without it being overly bureaucratic.
Yes. Because, can I just say, since I mean, you'll have understood our case. That at Te Pito Whenua in particular, but also with the areas around the support activities there in terms of parking and things. You know, effects are internalised. There's a bit of a disjunct. Frankly, we understand why temporary activities need to be regulated generally throughout the district. These sorts of activities as defined, but they're anathema to this place because, frankly, the more the merrier. You know, it's a space that is made to be used for activities like this. We thought, you know, removing any limit might be one way to fix, but I hear you loud and clear that there are other ways. And we can think about that. Back to you, Councillor.
I mean, as this is a special purpose site,
Yes.
there is the opportunity to define and provide for activities that won't otherwise upset other definitions and provisions that apply district-wide. And that might even come out of how do we name things. So
I would say that
I think about this a little bit more.
I would say that we all see the Waitangi Day and the celebrations that week in Matari and things. So these are all things that should be enabled on their side forevermore. We all innately understand that, but it would be good to have some planning clarity around it. You wouldn't want some officer without some context or something, you know, or a member of the public or something in 10 years' time asking the question. So I do think some more can be done to make it absolutely clear that certain things are enabled.
Mr. Chair, the issue that Nanette brought up before about obstructing in a public place like the landholder to a trust. We can trespass and charge, so it's not technically, you can just walk on it anytime you like. There are rules about what you do on the property at time, and it's the trust that sets those.
Okay.
So will you give some consideration to the process, the timeframe? Is it more that, or should we? Would you like us to suggest timing and process?
Yeah, I'm thinking we get the clear message from council officers that one, first of all, we want to talk about genuine temporary activities. And then see what sort of clarification in terms of number or duration can be done to give maybe comfort. And I think in this question of maybe a number might have to be conceded.
Yeah.
I'm not saying it has to be. I want to have, so I want to think about this overnight.
Sure.
And I think we'll probably end up having more of a discussion with the council officers tomorrow. We'll attend. And see, I mean,
Just at your disposal, sir. You're understood.
we'll have a good think about whether we need to try and send a direction. I want to see what we can get between the parties first.
Yeah.
Right.
Yeah, we're more than open to do that.
Thank you.
And you don't need us to tell you to have a chat, keep talking. Please keep talking.
We will.
Okay, well, I think we can wrap that up. Yeah. Okay. Thank you very much.
Thank you.
Really well considered detail.
There is one more slide.
Oh.
Just when you thought I was done.
Oh, the archaeology.
Minor amendments.
I wonder if
I just wanted to know, you want to go to the next one for me, Adrian? Sorry, there we go. The Paparihia Recreation Subzone has been referenced twice within WES S2 with different recession plans applying. The correct reference is item 2, which establishes a 55-degree recession plan. The 35-degree recession plan applying to the Whakanga tourism subzone should only apply where the site adjoins the Te Pito Whenua Treaty Ground subzone. This has been clarified within the standard And then the third just seeks to include an exemption for setback and sunlight in relation to the road boundary as discussed earlier. While I have not included a specific slide on for this, there was a matter raised by Mr. Brown regarding unrecorded archaeology. In his review included Appendix 5 to the Section 42A report, Mr. Brown has suggested that an archaeological management plan for the estate may be required to ensure that proper process is followed. His main concern is that the resource consent process currently appears to be the trigger for consultation with Heritage New Zealand, rather than consultation occurring at an earlier stage. This does not reflect my experience. Waitangi Limited and Heritage New Zealand have an established relationship, and all activities proposed on the site have been consulted on prior to my involvement. In some cases, consultation occurs even when a resource consent is not required. A recent example was the removal and replacement of a hedge. As this is an established garden, the activity does not trigger resource consent for any soil disturbance. However, consultation was undertaken due to its proximity to the treaty house and the potential visual impact of the. Another example is water fountains going on the treaty grounds. Again, that didn't require the need for resource consent, but was discussed with Heritage New Zealand. That's it.
And thank you again, commissioners. Sorry, there might be some questions arising out of that, but otherwise, the Waitangi staff will look forward to you visiting on 9 o'clock, I think, on Wednesday. You due. Ralph Johnson, as I say, will show you around.
Yeah, we'll let you know when we're going to visiting. It's probably going to be in the morning. We've got about potentially got about 6 slides we can go to. I don't know if we're going to get round to all of them, so we might have to pick one. It's definitely going to be one. So we'll be in we'll be in touch with. Before we do go on to the excluding signs and temporary events, are there any other questions of clarification that any officers would like me to?
No, but would you like to hear from Dr. Brown and speak to what has just been said and speak to all?
Yeah, that's precisely what that question was trying to get. So.
Yes.
Yeah, look, I appreciate that. I guess my concern is that, you know, you often fall within these systems, but not necessarily like at the moment. People are obviously operating in a highly, I can see that in these provided to me. But what I was trying to get at here is, this is something that's over and over again. It's a nationally significant place, nationally, important historic site, no management plan. I just don't, it doesn't really square to me with what would be the gold standard for this sort of place, to my view. And so I suppose my concern was just around this process of change is, if you don't have good systems in place, at the moment you've got the people, in the room that clearly do really good work, but that was my concern with that. Like at the moment, so those examples that you've given, fantastic, that's great to hear. I didn't know those examples are completely taken on board. But yeah, there was that broader concern, I suppose, for me, and that's where it's coming from, is that the basis for it being a special purpose zone is historically and culturally important, and yet it doesn't seem to be a standard that we might expect. Pompelia House has got a conservation plan, Antrim House, range of different places around the motor have got these things that govern these processes. And that was all I was going to. And it may be outside, I completely understand, but in the spirit of kind of collaboration, I suppose that's much. It was more of a comment around collaboration as much as anything. I understand it might be outside the jurisdiction, but that would be something. But for just as an example, there's 136 sites on the property. It's not just here, and 27 of them are mapped to a good standard. So that's just under 20. The rest of them are within 100 by 100 meters square. So in terms of management, even with best intentions, particularly in the western zone, and the general activity, but you could have the best intentions around consultation. Because of the standard of that institution environment. And again, not through any fault of anybody's, it's just what it is. It's a little bit like the sign points out, it's just kind of, roll with it. So there is those processes. So if you had an overarching process, overarching things planned that is in place, that might address that issue. If that issue arises down the line.
So are you looking for an archaeology management plan to be part of the provision?
Yes.
Or is this possibly able to happen through another mechanism?
So this is what I was just saying. This might be kind of more of a collaborative thing, not necessarily me, but just more might be more suggestion that goes to what could be thought about down the line. I appreciate that, having spoken to Jordan about how that fits within the.
What I'd like to hear probably tomorrow is if that is an outcome that you particularly want, what's the method? Part of this process, and if so, where does it fit? And or is it potentially another method?
I guess the question to that maybe to submitters, maybe to the archaeologists as well. Is it different in because of the way that it's managed in terms of the board and statute? You know, the way that Waitangi Treaty Grounds are managed and administered in the partnerships within that board compared to that science? Because it's been proposed to use the mechanism of regulation through district plan, whereas there may be other legal mechanisms that address that entirely. Are we doubling up on something that's not needed necessarily, it's already being done through those partnerships?
My view is definitely that it should sit outside of the district plan process, and that's mostly because Heritage New Zealand and Waitangi have such a good relationship that they can come up with their own things outside of what we're doing.
Well, perhaps we can explore that with the next submitter.
Could I just comment too, the tikanga whakahaere are there specifically to address any overarching cultural concerns. And that's why they haven't been measured against the WES provisions, because they actually need to be sitting in an overarching position so that the interests of Haukainga and the Te Tiriti o Waitangi are at the forefront of all planning matters. And I have admitted in the report that it is a starting point, but it's a necessary starting point. So we have started, and it is a draft, but it's a start. So if there are possible solutions or suggestions to how we could make that better, that would probably be more helpful. Then there is no management plan, because we have started to approach it, and there are layers, Haukainga, Ngāpuhi wide, Te Iwi Māori wide, the country wide, the trust board, the Waitangi Limited. And so there's so many layers to this that are not the same as every other resource consent for or a special purpose zone application. And so the tikanga whakahaere has literally gone through all of these examples of Māori governance to find the best way for us to explore that. And it is a draft, but it's a starting point. So we have started. And yeah, I would welcome any recommendations or suggestions to make it stronger in your professional opinion.
It might even be outside scope in terms of what we were able to do by way of consideration of these submissions anyhow. And that's a working document for the group to look at. I think it's something that we can specifically address. Maybe it's a recommendation.
Yeah, another point is Waitangi have only just completed more a statewide archaeological assessment as well, in conjunction with Heritage New Zealand. So a lot more sites have kind of been, I understand, refined and identified as well. So.
Not as that might be true. I mean, yeah, that's I understand you have new ones identified. Build this get this new on survey, but it's still as I say, just as of right as we speak, please see them more well. So I appreciate what you're saying. I understand that's the process.
Yeah, and I don't want to open up an ongoing channel of conversation here, but
We're all having a really good conversation. Look, maybe I'm gonna call the afternoon adjourn and encourage you guys to keep talking. While you have a cup of tea.
Before you excuse them, there's two matters that we wish to raise. So what do you get?
I'd like to focus on Heritage New Zealand's submission after the afternoon tea break. So
I've just got one matter and then James has got one meter. I would just like some clarification from Ms Jacobs, whether she wants that NFR Rule 1 wholly dealt with in the Waitangi Special Purpose Zone, or does she want to split it between the natural features landscape chapter and the Waitangi Special Purpose? Or are they just that would be really helpful. The other thing today, and I appreciate, and it's no criticism of my friend at all, but it came out that she wanted that the rule around this NFL Rule 1 is now, as I understand it, 30 metres squared permitted, and there's now, it's a split, it's now 30 to 50 RD and 50 D. I'd like some more evidence or some more understanding around that, because that's not where we landed. And I appreciate this has been a really grueling process, for want of a better word, getting the chapter. So if I could just have some more evidence or some discussion around that. So the two things I would like around that would be really helpful for me.
Yeah. So where the 30 square metre standard was, where I proposed that come in, was in the WES S4, which is the building and structures standard, and that would limit it to 30 square metres. And so the way that rule went to, the activity status that landed on, if you infringe that, was restricted discretionary. So that would sit under the WES standards. Then NFL 1 or R1 would be in the general chapter. That is where the 50 square metre would come in as proposed. And rather than an activity being infringed more than 50 square metres, rather than that go to non-complying, it's proposed that go to discretionary.
That would sit in
the general.
Sorry.
Just to, yeah, the reason for keeping that in the general standards is that's the direction of national planning standards. So we've tried to basically align as much as possible with the national planning standards.
Thank you. So,
James.
Thank you, Mr. Chair. Just a question whether the Te Araroa Trail that runs through the estate would be considered a public place in terms for the interpretation of some of the rules that have proposed. I know we've had a bit of a switch around between public place and reference to the estate itself in terms of sign visibility, but whether they would consider that would be applicable in that instance.
Does anyone want a response to that question? I'm thinking that we're probably going to allow you to give us some sort of written response. We're not asking you to answer all these questions and provide all the different detail. And I think we made that section. I think because we've got this reverse process, and we've really dived deep into some of the provisions. We'll let you have a chance to provide something in writing. And we've been looking at delaying the right of reply from council officers with regards to previous submittals. So we probably want to be the same opportunity. And as I say, we might end up clarifying what we'd like you guys, people, to do tomorrow as we talk with council. So, if you'd like to offer an answer, I think it's a relevant question. If you'd like to offer an answer to Mr. Orwell's question now, by all means do so. Or you can have a think about it and put something in writing.
Yeah, I'd like to take time to think about it,
Yeah.
because I think there's a few things to consider
Yeah.
in responding. So yeah, if we can come to that writing, that would be great.
Yeah, I'm tempted to give you a legal answer off the hook about easements and public accessibility and things, but yeah, well, I'm not these terms in the plan, so I think as Rochelle says, it'll be good.
Okay, well, thank you, James. That's going to be responded to, but I don't think immediately.
Thank you.
Does anybody like a cup of tea? No, we've got afternoon tea here, everybody's welcome. If you want to continue discussions with each other, by all means.
Thank you. And
Keep what you say to the panel members.
a couple of us have to head away, so I just want to say thank you again for hearing us.
Okay, thank you very much. No.
Stopping the recording.